Good morning, everyone, and welcome back to Coffee with Craig, where we talk about all things firearms policy, politics, culture, media, you name it. We're talking about it right here on Coffee with Craig. So please take a moment, like and share the program so that your friends can join in the conversation. Also, if you haven't already done so, make sure to subscribe to our YouTube channel and follow us on Facebook, YouTube, Twitter, Instagram, and make sure in the case of Facebook and YouTube, you hit the notification button. That way you'll get the notifications as soon as we go live, and you can participate in the live chat as it's going on. Finally, want to make sure you visit fpcgear.com. That's fpcgear.com. It is the place to go to get all of your Pro 2A swag. T-shirts, coffee mugs, hoodies, stickers, stuff for the office, stuff for the home, you name it, it is all there. And the best part is, every dollar that you spend goes right back into the fight for our right to keep and bear arms. So you can support the Second Amendment and you can look good doing it. That's fpcgear.com. All right, let's get into today's topic. Everybody's been messaging me all weekend about this. That's why I was so glad that Monday would finally come so that we could have this conversation and talk about it. And that is Duncan, the magazine ban, or the overturning of the magazine ban, has been upheld by a three-judge panel of the Ninth Circuit Court of Schlemiels. I'm sorry, the Ninth Circuit Court of Appeals. And to talk about this, kind of help us all to kind of understand the implications and everything, we have the Director of Legal Strategy, Mr. Adam Kraut, and we also have Mike Piwowarski of Arms Room Radio joining me here in Detroit, Michigan, talking about, once again, we're just talking about this another fantastic victory for gun rights. How you doing, Adam?
Great. How are you guys doing?
We're doing good. We're surrounded by women and guns.
And I women suppose there could be worse places to be. Where are you guys?
As long as we are in Detroit, Michigan. Yeah, we're doing. So we're at an event that's being put on by Rick Ector of LAID, Legally Armed in Detroit. And he's trying to make sure that the ladies of Detroit. He's trying to make sure that the ladies here get laid.
He is. He's doing a very good job.
He is.
Working his way through.
Sure that happens.
1,500 women this weekend. Working his way through.
1,500 women. It's a record for him, right?
He's very tired. Very tired,
He's
man.
He's very tired by the time this weekend is over. But they're providing free training to women. It's a two-day event, but they're providing free training. They come in. They get a classroom session.
Yes, they do.
Then they also get to go to the range and shoot.
Yes, they do. Yeah, some basic firearms familiarization. For 90% of them, women have never touched a firearm before. And I'll tell you the unique thing that we found talking to them here, before we jump into the regular topic, is that they're here with other people that have in the same situation, never touched a firearm, and they wanted to have this experience together rather than go to a range and feel intimidated by people that were pros and experts. So the gathering of all of them doing this for the first time together is the reason many of them are here.
Exactly.
That's awesome.
Yeah, it's phenomenal. So, do me a favor, help hip the folks. What exactly did the court say with Duncan? What exactly happened? All we know is a win. What exactly was it?
So Duncan was a decision last year from Judge Benitez. You guys may remember Freedom Week, where everybody just went nuts buying magazines, and that was a district court decision where Judge Benitez found that California's magazine ban was unconstitutional. And he went through a very lengthy analysis. His opinion was extremely long, but it was very well written, well reasoned. And of course, the state of California wasn't going to let that slide. So what did they do? They appealed it to the Ninth Circuit. And that was what happened yesterday. That was the result of that appeal. In a 2-1 decision, 2 of the 3 judges on the panel, they came and affirmed the lower court decision, finding that California's magazine ban was in fact unconstitutional. Now, one of the interesting things about the opinion itself was that it applied strict scrutiny rather than intermediate scrutiny. And for those that aren't familiar with it, essentially, the lower courts have kind of created this 2-step test. One being like, first, does this conduct that the law deal with, does it burden conduct protected by the Second Amendment? If the answer to that question is yes, then we move to this next part of the analysis where we try to do a means and scrutiny test. And there's a lot of pushback about that from attorneys like us here at FPC and throughout the community trying to litigate these issues, and as well as Justice Thomas most recently in a dissent in Rogers versus Grawal. He said that this test appears to be, entirely made up. So one of the interesting things, though, about it was that they applied the highest scrutiny, the one that requires the government to have a compelling and the law to be done in a narrowly tailored manner, which is the highest bar.
How often does that happen? How often does that happen, by the way? On gun stuff.
On gun stuff, it's very rare. Usually, intermediate scrutiny is the one that courts are using, and the watered down version of it. So it's intermediate scrutiny and name only is really what we'd kind of call it. Mm-hmm. Now,
really
of course, our position, yeah, it might as well be by the time you're all said and done with it. Now, at FPC, our position on the issue has been that we look at the text as informed through history and tradition. And as such, a lot of this stuff wouldn't even come close to standing. But unfortunately for us, as of now, the courts haven't quite adopted that view. So it was interesting to see that a court applied a more stringent test than normally, especially in this context. And especially the court essentially said that, look, there is a compelling government interest in keeping its citizenry safe and in keeping the police and like the two other things that the state of California put out there as compelling reasons for this. But the court said in the same token, this isn't the narrowest means to achieve that goal, and thus it doesn't survive a strict scrutiny analysis. And likewise, it doesn't survive the one below, being intermediate scrutiny. So this is unconstitutional. So that's what the decision was. Now I know what the question everybody has is, can we go buy our magazines?
Right.
And the answer to that is, well, maybe not quite yet. There's a couple things going on here. So first, the most important thing is there's a partial stay of the injunction that was issued at the district court. So the district court originally, when it decided the case, enjoined the state of California from enforcing the statute as a whole. Just gave the plaintiffs the relief that they wanted. Then when they appealed, it implemented a partial stay. And the part of the order it stayed deals with the part where it's a crime to possess, import, manufacture, sell, purchase, receive high-capacity magazines. And so that part of the injunction that was issued is stayed, meaning it's not in effect. So the force of California law as to that point is currently in effect. Now, if the plaintiffs in the Duncan case file a motion to lift the stay and that order is granted, that might change the landscape some. And then we also have to look at what California is going to do. California could certainly do one of two things. It could request reconsideration of the opinion, or more likely it's going to ask for en banc review. And en banc review is where the court as a whole hears it. In California, in the Ninth Circuit, I believe it's an 11-judge panel for en banc. It varies from circuit to circuit. So what could happen with that, and we saw it with Peruta as an example out of the Ninth Circuit, and we saw it with Colby out of the Fourth Circuit, was the en banc courts reversed the panel decision. So you had a really good panel decision that, the plaintiffs that got what they wanted. There was a little bit less of, the snake being treaded on for Second Amendment rights. And then the en banc court came in and said, no, actually, this law is good to go, and tough luck. And at that point, you're left with a cert petition to the Supreme Court. And as we saw this last session, it doesn't really seem that they're interested in hearing Second Amendment-related cases. So that's kind of where things stand with that. One of the cool things about reading that opinion yesterday, our research, Joe Greenlee, drafted an amicus brief on behalf of FPC and FPF and a number of other organizations. And in the brief, one of the things he did was he went into a fairly lengthy analysis of this dangerous and unusual test that's out there from Catano. And it was cool to see the court really did take that to heart and went through and put it in its opinion. And that was something that was only found in our brief that was submitted. It wasn't submitted by any of the parties. So that was cool to see that, our work is being looked at favorably by the courts.
Now, just real quick, I know Mike had a question for you, but real quick, why is it that, people are like, well, why don't the groups just all come together and just file one lawsuit instead of people filing these friend of the court briefs? How important are these friend of the court briefs? And what difference can they make in cases? Sure.
So an amicus brief or a friend of the court brief, they can be very important if they're done correctly. A lot of groups, and not just in the Second Amendment world, I'm certainly not saying this related only here, but generally speaking, a lot of groups, when they file amicus briefs, aren't really doing what they should be doing. And by that I mean, when you're filing this kind of brief, what you should be doing is bringing stuff to the court's attention that the parties themselves are not. So if you have, for instance, what we do, like historical information, research that's new and not really out there anywhere else, bringing information to the court that the parties themselves haven't. Unfortunately, a lot of times what you get is parties submitting things that, amicus parties anyway, submitting things that the parties themselves have already said, or they're just treading old ground, saying the same thing, just trying to, like, we're going to file this and do this too. So if the amicus is putting in information in front of the court that's new, novel, and useful to the court, it could be very useful at the end of the day. As to why all the groups don't come together and just file one big lawsuit, we obviously have worked with SAF and the NRA and a number of other organizations. Most recently, as the COVID stuff is a good example of that. And then sometimes it's just a matter of resources. We can't all jump in on the same thing. Sometimes we see there's an opportunity to litigate the matter in a different district. Perhaps there's a more favorable judge. There's any number of good reasons. It's not necessarily because there's any bad blood between the organizations or that we don't want to work together. Sometimes it's just a tactical decision.
Adam, you mentioned a little bit talking about what the status of Duncan might be, depending on what California decides they want to do with it. We're here at this event. There's people here from all over the country. We were sitting here talking about Duncan, and we talked to specifically some people from New Jersey and Maryland, and their question was, well, what does this mean for me? I'm in a state that's magazine restricted, and those of us that don't get to we're not the lawyers. We don't file the briefs every day. For those other people, what has to happen? What are those theoretical steps in the legal process for something that applies to the to the ninth would have to apply to the fourth as well? Sure.
So that's a good question. And for those of you that aren't lawyers, good choice. Way to go. Wouldn't necessarily recommend it, but that's a question a lot over the last day or two, and just generally in the past as to, there's a decision that comes out and it's from a circuit court. How does this affect me? And the answer is it very well probably doesn't unless you're within that circuit. So here's the deal, right? When we're talking about the federal judiciary, we have three different levels. You have the district courts, which are the lowest level trial courts. You have the courts of appeals that hear appeals from those trial courts. And then you have the Supreme Court at the tippy top, right? The courts of appeals are broken up into 13 different courts, and depending upon which circuit you're in, and the states underneath it fall. So, for instance, I'm in the Third Circuit. I'm Pennsylvania. The Third Circuit's Pennsylvania, New Jersey, Delaware, and the Virgin Islands, I believe. So, a decision out of the Ninth Circuit isn't binding on any of the courts that are within the Third Circuit's territory. However, it could be cited to as persuasive authority. So by that, essentially, when you go into court and you're at the district court and you're arguing a case, the authority that comes from either the court above it or the Supreme Court is binding on that court, which means it has to follow it regardless of whether it likes what it says or not. When you get to the circuit courts say, well, our authority that's already out there is binding on us, and obviously the Supreme Court governs us as well. However, if we overturn a prior decision, then we can, change what was binding on us that was created from us. And then obviously the Supreme Court is the highest, and it can overrule itself if it so chooses. So if you're in a circuit where that case law is from, it's binding on the district court, and it's likely binding on the circuit court as well. If you're in a different circuit court, so like say I'm in the third and this is coming out of the ninth, what we could do is we could cite to it as persuasive, saying like, look, the court over here found this is the analysis it went through, this is why it's right, this is why you should do that. But it doesn't necessarily mean the court has to do that.
Very cool. Very cool.
Okay, so they'll have to wait, like you said. If this goes further in California and becomes a Supreme Court case, it could affect them. But for now, it's a sidebar and maybe could be used in an argument in a separate circuit.
Yeah, as of right now, where it stands at best, you could point to it and say, look, the court over here said this, you should do this as well. And unless the Supreme Court, ultimately hears this case and decides that, yes, this is unconstitutional, that's about as good as it's going to get right now for anybody not in the Ninth Circuit.
Okay, I think that answers the questions for them.
Adam,
Yeah.
thank you so much for the update. Where can folks find out more about the legal work that the FPC is doing, as well as get updates on key court cases?
Yeah, so you can definitely check out the website, firearmspolicy.org. There's a legal section where we're posting, all the briefs we've been working on and new lawsuits that are happening. That all gets posted there. If you're not following us on social media, although if you're watching this, you probably are, but, Firearms Policy Coalition on Facebook, Gun Policy on Instagram, and on Twitter. And I'm sure there's a slew of other social media things that you kids are doing that I don't know about. So,
Excellent. Once again, sir, thank you so very much. We appreciate all the work that you do fighting for our rights in dem courts.
yeah, pleasure. Thank you so much for having me, guys.
Excellent,
Thanks, Adam.
excellent. Ladies and gentlemen, Mr. Adam Kraut. All right, folks. Well, hey, that's going to be it for today's Coffee with Craig. It has been fantastic. A nice opportunity to celebrate a Second Amendment victory. We want to make sure encourage you guys, please make sure you guys like and share the program. Tell your friends about the Firearms Policy Coalition. We are the home in the fight for civil rights. You got to use them or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.